Hosanna Tabor Evangelical Lutheran Church and School v. Equal Employment Opportunity Commission, 565 U.S. 171, 2012, is a United States Supreme Court case in which the court unanimously ruled that federal discrimination laws do not apply to religious organizations' selection of religious leaders. Background: in 1999, Cheryl Parrish started teaching at Hosanna Tabor Evangelical Lutheran Church and School in Redford, Michigan. While Parrish led students in prayer and taught a religion class several days a week, her job primarily consisted of teaching grade school art, science, social studies, and music. In 2004, Parrish left on disability and was diagnosed with narcolepsy. In 2005, after being cleared by her doctors to go back to work, the school told her that they already hired someone else. Parrish then threatened to file suit, and so the school promptly fired her for insubordination and disruptive behavior. Parrish sued for unlawful dismissal under the Federal Americans with Disabilities Act. Opinion of the Court: all 9 Supreme Court justices agreed with the decision written by Chief Justice John Roberts that the Establishment Clause prevents the government from appointing ministers, and the Free Exercise Clause prevents it from interfering with the freedom of religious groups to select their own. Moreover, because the respondent in this case was a minister within the meaning of the ministerial exception, the First Amendment requires dismissal of her employment discrimination suit against her religious employer. The decision explicitly left open the question whether religious organizations could be sued for other reasons with the sentence, "We express no view on whether the exception bars other types of suits, including actions by employees alleging breach of contract or tortious conduct." Concurrences: Justice Clarence Thomas wrote a concurrence, in which he eschewed the use of any specific test for determining who qualifies as a minister, writing that he would like to defer to a religious organization's good faith understanding of who qualifies as a minister. Justice Samuel Alito wrote a concurring opinion, which Elena Kagan joined, stating that the word minister used in the decision should extend to similar titles for other religions such as rabbi for Judaism or imam in Islam. Reaction: support. The Family Research Council expressed support for the decision. In a press release, a spokesperson for the organization stated, "We are pleased that the Supreme Court rejected the Obama administration's profoundly troubling claim of power over churches, and glad to see that the Supreme Court has stayed out of the Lutheran Church's affairs and allowed its internal rules as a body of believers to stand." While FRC criticized the Obama administration, President Obama actually made no comment on the case, which was one the government began under the George W. Bush administration. However, the Obama administration, namely the Justice Department, did in fact file an opposition brief that asserted the ministerial exemption should be severely limited. 5 days following the decision, Mitt Romney praised the decision, saying, "We are very fortunate who are willing to stand up for religious tolerance and religious liberty and the First Amendment of this Constitution in this country." Criticism: in a January 12, 2012, editorial, The New York Times concluded that the decision gave sweeping deference to churches which does not serve our society wisely. Although the court does not provide much guidance on how to proceed in future lawsuits against churches as employers, the ruling has broad sweep. It abandons the court's long-time practice of balancing the interest in the free exercise of religion against important government interests, like protection against workplace bias or retaliation. With a balancing test, courts consider whether a general law, if applied to a religious institution, would inhibit its freedom more broadly than justified, and, in those circumstances, courts could exempt the church. In her brief, Ms. Parrish warned that expanding the ministerial exception to include workers like her would allow a religious organization, for example, to retaliate against a teacher for reporting sexual abuse of a student to the government. Impact: some religious organizations have attempted to use this ruling to exempt themselves from anti-discrimination laws they apply to non-ministerial employees, simply by adding minister to their title. In 2014, the Archdiocese of Cincinnati ordered its 2,000 teachers regardless of religion to sign a detailed morality clause that critics say focuses on pelvic issues. The new contracts forbids teachers from living together, having sex outside of marriage, using in vitro fertilization or surrogacy, exhibiting a gay lifestyle or any speech expressing support for these things.
Please subscribe and thanks for watching.